Good morning. Are you Jeremiah Davis? What does your shirt say? Just trying to figure out what it says. I can't read it. Make sure it's appropriate. Mr. Smith, announcement. Mr. Smith, Mr. Parker, announcement.
Your Honor, last time I asked the court for some time to provide a video to the district attorney's office, and my client and his parents came in and provided me the video, and I think it should.
If it was sent it to me last week, I was out on vacation. So
Okay.
I was going to ask for a reset, just give me a chance to review it.
Okay, we'll just do one more normal reset to give y'all time to take a look at all of that. Mr. Davis, stay in touch with Mr. Parker. He'll let you know when you need to be back. Okay?
And I have to kind of talk, because it's hard to see who's the daughter. Okay.
You're free to go. David Lewis, Mr. Parker.
It's Preston's.
Preston's. No, you're welcome.
That's what's on his email.
It's contagious.
Took me forever. I could never email him forever.
I know, I still have a. All right, are you David Earl Lewis?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Lewis, in cause number 240830, you're charged with the state jail felony offense of unauthorized use of a vehicle from January 26th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them? Okay, is there anything specific that you don't understand?
I'm not sure.
Okay, well, so let me
I-
ask you this. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So do you understand, that means that you can't change your mind if I follow this agreement and give you the probation. You can't change your mind later and say, oh, no, I didn't do it. Do you understand that?
Yes, ma'am.
And it looks like the agreement that you reached is for a 3-year deferred adjudicated probation with a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand that?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone that. You're a U.S. citizen? You were born here in U.S.? Okay.
I think it's confused. I've explained to him that he's never been in trouble before, that you do everything you're supposed to do, you can possibly get off early, and I encourage him to do that.
So, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
Mr. Nichols, what's the state's position on waiving pre-sentence report?
I see no criminal history other in this case, Your Honor, so I have no problem with it.
All right, so Mr. Lewis, I'm going to waive the pre-sentence report, and I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm not going to find you guilty today. I'm going to follow that agreement that you made and defer all proceedings and place you on probation for 3 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity, because that deferred probation means you are not a convicted felon right now. And if you complete the probation satisfactorily and do everything you're supposed to, then at the end, the case is dismissed and you will never be a convicted felon. The other side of that, though, is if you violate any condition of probation, if you don't go to your appointments, you don't pay your fees, you test positive, you commit a new offense, whatever it is that you're supposed to do or not supposed to do, if you do that, then you could be brought back into court, you could be convicted, so you become a convicted felon, and you could be sent to prison for between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
All right. I'm handing you the trial court certification. That shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. The lady sitting right there at that desk, she's with probation. She's going to call you up when she's ready to go over your paperwork. Okay? Good luck to you, sir.
Thank you, Your Honor.
Thank y'all. Good morning. Are you Kaden Jones? And Ms. Jones, in cause number 24-2155, is charged with assault on a peace officer, and in 24-2156, charged with obstruction or retaliation. And what is the announcement?
Your Honor, we have received an offer from the state. I have not been able to meet with Ms. Jones, so if I could we should be able to get this resolved by the next court setting. I just need to meet with her.
All right, I'm going to reset it one time. Ms. Jones, it's very important that you call and make an appointment with Ms. Holmes. It's not up to her to try to reach out and find you and make you come in to see her. You need to get that done, call, make an appointment so y'all can go over everything she's received, and then we'll get it taken care of at the next court date. Okay, you're free to go. And then Lamarcus Liggins, Ms. Holmes.
Okay, so I got a question. You have the original document. So Mr. Liggins, they had him on a parole hold in Walker County for a month, and we would like for him to get that credit, but we didn't. He was on bond here, but Walker County had put a parole hold on him, and he was in custody for a month. They have since released him, and he's reinstated. But we want to make sure he gets the credit, because the offer was the 30
And
days.
I've offered to reduce it to fit that time, Your Honor, based on facts of the case.
So we have the documentation from Walker County. You have the original.
If
Yeah.
he's on bond, I don't think I can legally do that. You know what I mean? If
There's not a hold, there's no way to fix that, is there?
I mean, if he wasn't on bond and just hadn't made that bond yet, then that's something that's a little easier for us to do. But if he's actually on a bond, then that bond shows up in our system. And if we go in and say he gets credit for time, you've looked this up, help me out.
Briefly, Judge. I mean, the case law says that
I can,
If there's not a hold, there's no way to fix that, is there?
I mean, if he wasn't on bond and just hadn't made that bond yet, then that's something that's a little easier for us to do. But if he's actually on a bond, then that bond shows up in our system. And if we go in and say he gets credit for time, you've looked this up, help me out.
Briefly, Judge. I mean, the case law says that
I can do whatever.
Or you can give this defendant credit for any time he spent in custody anywhere, as long as our case was pending. Now, out on bond, I don't know about the issue of being
The
out on
bond,
bond. That's a
okay.
whole nother animal. But what our research was whether or not someone was in custody in another jurisdiction, another state, while our case was pending, notwithstanding whether or not there was a hold, you can give them credit
Even
for
if
that
there's
in
not a
custody
hold.
confinement.
I mean, who's going to complain, I guess, if we do it? Is it physically possible to do y'all can make it happen?
Because this shows his at the top when he went in his release date. He went in on 5/12, 5/11,
5/11.
and was released on 6/12. Because the offer was to reduce it to give him 30 days with the credit.
And if he's already been in and bonded out, then that's actually better, because we have, make sure you have that, and because we have then him, because if not, then he would have to go at least get in and get out. But if he's been in our jail and bonded, that makes it easier.
Yeah. So I
We're
think he
good?
had like a day in our jail.
Okay. Yeah, I'm gonna take care of that paperwork
Judge,
then.
I mean, obviously it's all pending your approval. The reason that the offer is the way it is because of the facts, considering that it's a shoplifting. He does have old priors, and he was on parole. But based on my review of the file, I thought 30 days for time he's done was a fair resolution. What I'm not showing is anything a lot of that time was incarcerated, but there
Yeah.
was nothing for a while. And so I want to make sure the court knew that, because I know how you feel about these cases when I do that.
Sorry. And parole is not gonna, are you still on parole?
They already moved.
And I spoke with his parole in Huntsville, Miss Harper, And, because we've been in touch and they've reinstated him and they don't anticipate to do anything further.
Okay, all right, y'all get the paperwork done.
Okay, thank you.
Yes, sir, yes, ma'am. And hang on to that, because I think I want that for the record, if y'all don't mind,
You can
just
have it.
for us to have.
Okay.
So Anna has those dates. Let's,
It's pajama pants. I know,
I mean, to risk your,
I know, there's,
to risk it all, it makes no sense to me. Ms. Holmes, let's take care of Deontay Randolph, that's the sentencing. Good morning, you're Paul McCorvey. And Mr. McCorvey, in cause number 241914, is charged with theft of property, and what is the announcement?
Judge, this allegation is a result from a probate matter that was going on, mainly dealing between him and his sister. There was a hearing dealing with some of this property earlier this month. My understanding, there's not any more settings set in probate court at this point. They're trying to liquidate a lot of the property now. I have not received the transcript from the last hearing.
Okay,
And my understanding of that last hearing, there was definitely some relevant information in regards to this property. That's the question here,
okay.
that his sister.
And you've made that request for that
Yes.
transcript?
I
Okay.
did.
All right, then, any issues that you know,
no, Your Honor, my notes are that they're waiting on some
transcript
court
still?
documents to help us solve this.
All right, so I'll do a normal reset about 30 days, see if you get that transcript between now and then. Stay in touch with Mr. Lewis so that when he does get that, you guys can go over it, and then we'll see if we can get an announcement the next court date. You're free to go.
Thank you.
Huh? Good morning, you're Lamarcus Liggins. Answer out loud, please.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
It will, Your Honor.
And we're going on count one only, and in that count to the lesser included, correct?
Yes, Your Honor.
Mr. Liggins, in cause number 242391, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class B misdemeanor, and that's from November 1st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And the agreement that you've reached is for 30 days in the Jefferson County Jail, but that I would give you credit, and I've already been handed that document that shows that you spent some time while on bond on this case in Waller County, Texas. Walker.
Walker.
Walker
County,
and it's
Texas.
approximately 32 days in their jail.
Okay, and that's everyone's understanding and request that I give him credit for that.
Yes, Your Honor.
All right, state tenders number 1.
No objection.
It's admitted. And sir, are you a U.S. citizen? Is there any evidence that Mr. Liggins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class B misdemeanor theft. Sentence you in accordance with that agreement to a term of 30 days in the Jefferson County Jail. I will give you credit for that time served in Walker County. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. Good luck to you, sir. You're free to go.
Thank you, Your Honor.
Thank you all for working that out.
Okay.
Good, you're Mark Garcia.
Yes, ma'am.
Thank you for calling ahead and letting us know that you were having issues. I'll recall that bond forfeiture. Mr. Garcia, were you able to get someone hired?
No, I wasn't, but I am waiting on one call back. I made a few calls, but everything was a little too expensive for me, honestly.
Who'd you talk to?
I talked to David Boyer, Chadwick Robeson, Herman Martinez, and I'm waiting on a call back from Jamal Johnson. I have a few other lawyers that I called on here, but they were just too much.
Okay. And you're working?
Yes, ma'am.
Okay, so I'm going to give you one more reset. You need to try to keep, as you can tell from talking to them, they all charge different amounts.
Yeah.
Talk to at least 3 more, if not more than that. See if you can get someone hired before that.
It's not a road cost.
So I can't recommend attorneys. I don't know some of those names that you were talking about, and so some of them might be from out of town. My suggestion is typically an in-town lawyer would probably be more reasonably priced. Google criminal district defense attorneys in Jefferson County. You're going to get a list of them that I think is probably different than that list. I
This is
don't,
the one they gave me for Jefferson County on Google,
okay.
some of them.
You also can walk across to the Bar Association. It's right across this lobby, the Jefferson County Bar Association. They have a criminal referral program, and they can give you a list of 3 attorneys. So when you leave here today, walk straight over there. There's a door. You just need to knock on that door, and they can. It's right here straight across. When you walk out this door, go straight across to the other side, and it's on this floor. So I'm going to give you another 30 days to see if you can get someone hired. Okay? Step in front of the clerk. Right here. All right, you are Shaniqua Washington. And Ms. Washington, I called your case this morning and you weren't here. Where were you? I can't hear and understand
I
you.
was late. My daughter was to come and she couldn't come.
Okay. So I'll recall that bond forfeiture. Did you get a lawyer hired?
And I called
You hired him?
I called from
No. You were here before, and I told you that since you bonded out, that you're supposed to go hire a lawyer. Do you remember that? Okay.
I talked to over there yesterday and then nobody
I need you to speak loudly and
nobody
clearly.
called me back though.
So for 30 days, how many lawyers did you call?
Ellen Parker, Joe Vasquez, and
What's the other one's name?
I can't remember his name.
Why wouldn't you write that stuff down?
It's a person to call.
Well, how does that make sense? If I test you this morning, you can have something in your system? I have a seat in the jury box. Let's get that tested. So, Ms. Washington, you tested positive for THC, benzodiazepine, and admitted to using PCP 2 weeks ago. Is that correct?
Yes, ma'am.
How'd you get here today? Answer out loud.
Okay, I said,
Okay. Stand right here.
yes, ma'am.
So obviously this is a violation of your bond conditions, and it is not safe for me to have you out while you're on bond for a felony using PCP, benzodiazepine, all the stuff. When's the last time you smoked marijuana and used benzo?
No, not weeks ago.
So pretty much had a big party 2 weeks ago, used it all?
Depression.
The pressure of what?
Depression.
Depression?
Yes, ma'am.
You do understand that all of these things makes that worse, not better.
Yes, ma'am.
Do you have a doctor that you're going to?
Promo, I don't know what happened to him. I just found a new doctor. I was.
Hold on a second. If you want to see if your client can get back real quick, we just reset it just because it had gotten so late. But if he just left, if you want to try to call him or have your office call him, if y'all want to take care of it with the plea today, we can do it.
Let me try to get him right now.
Okay.
See if I can get him on cell phone.
Thank you.
All right.
Okay. I don't believe that the last time you used was a couple weeks ago. You're not coherent. Hang on.
Yes, ma'am.
So what, Ms. Washington, I'm going to, hold on, let me find, what was her bond set at? Can y'all tell real quick for me? Nope, I got it. I'm finding it. I'm going to find that you violated your bond conditions by using all of these substances. And I'm going to raise your bond at this time, find that you're at large without, or based on those bond conditions, raise your bond I'm having a. This shows 6,000.
6,000, it is 6,000.
All right, I'm going to raise your bond to $15,000 in your case. A condition of that bond, if you make it, is that you have to wear a drug patch. You have to have that drug patch put on within 24 hours of your release and give proof to that to your bondsman. If you test positive on that drug patch, you're going to be right back in jail with a much higher bond. Do you understand? Go back with the bailiff.
Do I get the drug patch?
Your bondsman can tell you where to get it.
Okay.
Good morning, sir. You're Johnny Polanco? Yes, ma'am. And Mr. Polanco's case is set for trial to begin with jury selection on Monday. Is there anything that can be worked out today?
I think it's a penitentiary time offer. He
Okay.
conditioned as a case Mr. Smith has represented that will be picked up by the.
So,
federal
Mr.
government.
Polanco, Mr. Kimler has a vacation letter in for next week, and so we are going to reset your case to the next available trial docket. I do want to make sure that you understand that whatever offers on the table today will not be accepted after today. So, change your mind and you want to enter a plea today, we can get that taken care of. Otherwise, it'll get set for trial. If you later change your mind, you could plea open to the court or to something different than what's on the table today. Do you understand? Answer out loud.
Yes, ma'am.
And so do you want to stay on the trial docket?
Yes, ma'am.
Okay. We will move it to the next available trial docket. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back.
Thank you, Your Honor.
Who's that?